ban is dead. Here's what actually applies to your contracts now. Hi, I'm attorney Jeremy Eveland. I practice business law in Utah, Nevada, California, and Texas. I want to stress that this is not legal advice. Every situation is different, and every set of facts will have different outcomes in court. Now, I believe that when a business invests real money in training an employee, shares its proprietary methods, and trusts that person with its most sensitive client relationships, it deserves meaningful legal protection against having that investment walk out the door and into the arms of a direct competitor. The tension between these values is at the heart of every non-compete dispute I've ever seen. And right now, millions of employers and employees across the country are confused about where the law actually stands. They heard the FTC was going to ban non-competes nationwide. Then they heard that it was blocked. Then they heard it was abandoned. And most people do not know what actually applies to their situation today. I share this information because, well, quite frankly, confusion has real consequences. Employers are drafting agreements that may not be upheld. Employees are honoring restrictions that may not be enforced. Both sides deserve clarity, and that's what this video is about. So again, I'm Jeremy Eveland. I'm a business attorney licensed in Utah, Nevada, California, and Texas. And if you've been following the news about non-compete agreements over the last couple of years, you will have probably been on the roller coaster. In April 2024, the Federal Trade Commission issued what appeared to be sweeping nationwide ban on virtually all non-compete agreements. The rule would have made it illegal for employers to enter into, enforce, or maintain non-compete clauses with their workers, with only a narrow exception for senior executives in existing agreements. It was scheduled to take effect in September 2024. But that rule never took effect. It was challenged in multiple federal courts, and in August of 2024, the Northern District of Texas, in the case of Ryan v. FTC, issued a nationwide injunction, blocking the rule entirely. The court held that the FTC likely exceeded its statutory authority in attempting to issue such a broad substantive rule under Section 6G of the FTC Act. Then, in September 2025, the FTC voluntarily dismissed its appeals, officially abandoning the rule, and in January 2026, the FTC held a public workshop confirming that it will no longer pursue a categorical ban. Instead, it will use its existing authority under Section 5 of the FTC Act to challenge specific non-compete agreements on a case-by-case basis. So, the nationwide ban is dead, but that doesn't mean that the FTC is out of the picture entirely, and it absolutely does not mean that your non-compete is automatically enforceable. Let me explain what actually applies now. So, even though the FTC abandoned the broad rule, it did not abandon its interest in non-competes. On September 10, 2025, FTC Chair Andrew Ferguson announced that the Commission is redirecting its enforcement resources towards challenging specific non-compete agreements that it considers unfair methods of competition under Section 5 of the FTC Act. That is the same authority the FTC uses to go after deceptive business practices, and it gives the Commission the power to investigate and take enforcement action against individual companies whose non-compete practices it considers anti-competitive. So the FTC has been particularly focused on the healthcare sector. It sent letters to several large healthcare employers and staffing firms urging them to review their non-compete agreements and warning that overly broad restrictions on healthcare workers could trigger enforcement action. The Commission's stated concern is that non-competes in healthcare can limit patient access to care and suppress wages for workers who have limited alternate employment options in their geographic area. But the case-by-case approach means that there is no bright line rule telling you what is and is not permissible at the federal level. You have to look at your state. So, with the federal rule gone, non-compete enforceability is entirely governed by state law, and the landscape varies dramatically from state to state. On one end of the spectrum, California, Minnesota, North Dakota, Oklahoma have effectively banned non-compete agreements for employees outright. If you're an employer in one of those states, a non-compete clause in your employment agreement is almost certainly void. On the other hand, states like Florida and Texas generally enforce non-competes as long as they are reasonable in scope, duration, and geographic reach, and they protect a legitimate business interest. In between, you have states that have enacted specific limitations. Colorado, for example, prohibits non-competes for employees earning below a certain salary threshold, and it requires employers to provide separate written notice of the restriction. Illinois has a similar income threshold. Oregon limits non-competes to 18 months and requires the employer to provide a signed written copy of the terms at least 2 weeks before employment begins or at the time of bona fide advancement. Washington requires employer to pay the employee during the restricted period if the agreement is enforced. Each of these states has its own set of requirements, and if you are drafting or enforcing a non-compete, you need to know exactly what your state requires. I'm going to talk about Utah now. In Utah, non-compete agreements are governed by the Utah Post-Employment Restrictions Act. It's found at Utah Code Section 34-51-201. And under that statute, for any post-employment restrictive covenant entered into on or after May 10th of 2016, an employer and an employee may not enter into a post-employment restrictive covenant for a period of more than 1 year from the date on which the employee is no longer employed by the employer. Any non-compete that exceeds 1 year is void under this section. There are two important exceptions under Section 34-51-202. First, the 1-year limitation does not apply to reasonable severance agreement that is mutually and freely agreed upon in good faith at or after the time of termination. If an employee negotiates a severance package and it includes a longer non-compete agreement, that agreement can be enforceable beyond 1 year. Second, the limitation does not apply to restrictive covenants entered into as part of the sale of a business. So, for example, if you are selling your company and the buyer requires a non-compete as a condition of the purchase, that non-compete can extend beyond 1 year because of the context and the bargaining power are fundamentally different from an employee relationship. Beyond that 1-year cap, Utah courts still evaluate non-competes under traditional reasonableness analysis. The agreement must be supported by adequate consideration, must be protecting a legitimate business interest such as trade secrets, confidentiality information, or goodwill, and 3, must be reasonable with its geographic scope and the activities it restricts. A non-compete that is broader than necessary to protect the employer's legitimate interests is at risk of being modified or voided by a court, even if it falls within that 1-year statutory limit. If you are an employer using non-compete agreements, the most important thing you can do right now is audit your existing agreements against the current law in every state where you have employees. Do not assume that because you have drafted a non-compete agreement 3 years ago, it is still enforceable. State laws have changed significantly in the past 2 years. An agreement that was valid when it was signed may not be valid today, even if it violates a subsequently enacted statute. Second, consider whether a non-compete is actually the right tool for what you're trying to protect. In many cases, a well-drafted non-solicitation agreement, a confidentiality agreement, or an intellectual property assignment clause will protect your legitimate interests without the legal uncertainty and employment resistance that comes with a non-compete. Non-solicitation agreements, which prevent a departing employee from soliciting your clients or recruiting your employees for a defined period, are generally enforceable in most states and face far less judicial skepticism than non-competes do. Confidentiality agreements, when properly drafted, can protect your trade secrets and your proprietary information indefinitely. Third, if you do use non-competes, make sure every written agreement is narrowly tailored and clearly written. Specify the exact duration, the geographic area, and the specific competitive activities that are restricted. Provide adequate consideration. In many states, continued employment alone is not sufficient. Consideration for a non-compete signed after employment has already begun, and provide the agreement to the employee in advance before they start work with enough time to review it and consult with their own lawyer. The days of burying a non-compete in a stack of first-day paperwork are numbered, if not already over in most jurisdictions. So if you're an employee who has signed a non-compete, don't assume that it is enforceable just because you signed it. A signed agreement is not automatically binding if it violates your state statute or it fails to pass the reasonableness analysis. You need to pull out your agreement, read it carefully, look at the duration, the geographic scope, the activities it restricts, And then look at the current law in your state. If you are in Utah, for example, and the agreement was signed after May 10th of 2016, any restriction beyond 1 year is void by statute. If you are considering leaving your current employer and your non-compete concerns you, do not simply ignore it and hope for the best and cross your fingers. Have the agreement reviewed by a licensed attorney who understands your state's non-compete law. In many cases, an attorney can identify provisions that are likely enforceable or unenforceable and can advise you on how to transition from your old position to your new position in a way that minimizes your legal exposure. The cost of a legal review before you leave is almost always less than the cost of defending a lawsuit after you've already started with a competitor. Look, even though the FTC's nationwide ban failed, the direction of the law is clear. Most states are restricting non-competes, not fewer. Income thresholds are being raised. Notice requirements are being added. Duration caps are being tightened. And courts across this country are applying increasingly stricter scrutiny to non-compete clauses, especially those imposed on lower wage workers or workers in industries where restricting mobility provides little genuine competitive protection to the employer. The FTC's case-by-case approach also means that federal enforcement is completely unpredictable. If the FTC decides to make an example of an employer whose non-compete practices it considers partially egregious, the legal costs and reputational damage of an FTC investigation can far exceed the cost of simply narrowing your agreements proactively. Smart employers are getting ahead of this trend by replacing overbroad non-competes with targeted protective agreements that courts are more likely to enforce and employees are more likely to accept. The FTC non-compete ban is now dead, but the legal landscape around non-competes is more complex and more state-specific than it has ever been. So whether you are an employer trying to protect your business or an employee trying to understand your rights, the worst thing you can do is assume that what you've heard 2 years ago is still the law today. Review your agreements, know your state statutes, and if there's any ambiguity, get professional advice before it becomes a dispute. When you need an attorney, you can give me a call. Again, I'm attorney Jeremy Eveland. My phone number 801-613-1472, or you can click on the description, the link in the description below, see if we'd be a good fit to work together. I typically serve as general outside counsel for businesses. Again, I'm licensed in Utah, Nevada, California, and Texas, and I focus on business law, real estate law, estate planning, asset protection, and probates. So remember, this isn't legal advice. Every single case is different. If you need legal advice, you need to speak to an attorney licensed about your specific situation in your jurisdiction. So if this has been helpful, go ahead and give me a subscribe, a thumbs up, and I'll see you in the next video. Thanks for watching.